So let's talk about some of the documents that dropped from the defense, particularly like their responses to the state's objections to the motions to suppress. But I'm actually just going to focus on one of them today, and that's the pen trace, the trap and trace and pen register. Because I'm seeing a lot of people misinterpreting what the defense's objection is saying, particularly when it comes to the probable cause affidavit. Was it attached? Was it not? So let's get started.
Point that I'm getting at here is that Jennings and Payne went to Megan Marshall. They told Megan Marshall this. Okay? This is what he did. He said he took the affidavit of Lawrence Mowry. He assigned it to himself right here. And then he signed it. So I'm very confused as to how this document right here, he is alleging he has this affidavit. He is alleging the affidavit is a sworn statement of fact. He is alleging it's the affidavit of Lawrence Mowry. And then when you go through everything that is submitted, there is no affidavit attached. Where they're in front of Megan Marshall, they're submitting this in the application for the second AT&T warrant to obtain the trap and trace. They're saying we have A, B, C, and D, and yet the thing, it's not there. It's not there. And the affidavit that Payne references is not attached, not his or Mowry's. So it's very confusing as to how it got past a judge. We're not even sure how this made it past a judge, number one. Number two, the judge granted it when there was no supporting evidence, affidavit, or probable cause. Furthermore, an affidavit that was submitted is the affidavit of one officer, and another officer is assigning it to himself and using it to obtain warrants. And mind you, he's using it to get the FBI to put a pen, trap, and trace. You're literally violating someone's fucking constitutional rights at that point.
Okay. Cool your engines there. That's not what happened. Okay. The warrant had probable cause attached to it when they took it to Megan Marshall. Okay. Ashley and Brett Payne did not go to her without a probable cause affidavit. Now we're going to talk about the cut and paste that Payne did later with that boilerplate cover letter. But right now, we're going to focus on what the defense actually said was going on with that warrant and what was actually attached to the warrant, because it had probable cause with it when Megan Marshall signed it. Let's break it down. This is from the defense's objection, the defense's response to the state's objection to the motions to suppress the trap and trace warrant, the second AT&T and the trap and trace. And it says, the AT&T trap and trace or AT&T 2 warrant was general, and the affidavit was not incorporated into the warrant or served with the warrant. And then it talks about the Fourth Amendment, quotes, right of the people to be secure in their persons. And when you go on further in the document, it says, the court finds that Brett Payne, investigating officer, and Ashley Jennings, senior deputy prosecutor, has certified to the court that the information likely to be obtained by such installation and use is relevant to an ongoing criminal investigation. Okay, that's what Megan Marshall had put into the warrant. So, to me, that does incorporate the probable cause into the search warrant, but the defense is saying no. They're saying, while this language is unique to the trap and trace warrant, it does not incorporate the search warrant affidavit or any of its attachments. The search warrant affidavit did not accompany service of the warrant. The state, in its objection, attached the search warrant affidavit, its exhibit, and the order to install the trap and trace device. It did not attach documents that provide clarity that the search warrant affidavit was not included with the service of the search warrant. Those documents are therefore included in this filing as attachments, where a supporting affidavit does not accompany the search warrant at the time of execution. The details set out in the affidavit does not cure any deficiencies, U.S. versus Pilling, and we'll talk about that. Okay, did you guys all catch that? It says that the probable cause was not attached at the time of serving the warrant. Okay, so they didn't give it to AT&T when they served the warrant. Now, at no time has there ever been a law that states that the probable cause affidavit must be served with the warrant to a third party. It has to be turned over in discovery so that the defendant can look at it and challenge the probable cause, but it does not have to be turned over to the third party when serving the warrant, okay? The defense is not stating there was no probable cause affidavit when it was brought to Megan Marshall for her to approve the warrant. They're saying it wasn't attached when the warrant was served to AT&T. And now Anne is trying to use kind of an anomaly ruling from 2024. It's just kind of an obscure ruling where a judge ruled that a probable cause affidavit should have been given to a third party with a warrant because of saying the warrant was too nonspecific. So let's continue. Okay, we're continuing with some more of what the defense said. So they said the affidavit of Corporal Brett Payne swears that the warrant was served on 12/23/2022 by sending to the FBI for service. See Exhibit A, page 2. An FBI form similarly reflects that a prospective location tracking searching warrant for that included the pen register trap and trace for telephone number 509-592-8458 on behalf of the Moscow Police Department was served on December 23rd, 2022. See Exhibit B. On or about December 23rd, 2022, an AT&T mobility carrier request form was completed. See Exhibit C. I will show you these. Attached to the AT&T form is the pen trap and trace search warrant at issue. The affidavit in support of the search warrant not included. Okay, see, again, that's not saying that when Megan Marshall signed it, it wasn't included. It's saying when they served it to AT&T, it wasn't included. It says the return documents, the FBI form and the AT&T form do not reference the affidavit in support of a search warrant as having accompanied the pen trap and trace search warrant. See Exhibits A through C. Nor does the state produce such records in its objection. Well, yeah, I imagine they didn't produce it because they're like, here, it was produced with, you have the warrant. You can see that it was produced. I believe that's why they didn't produce it again. Now, I want to show you this because Miss Potts is trying to say that this was what was submitted to Megan Marshall at the time they went to get the warrant. But this is not, okay? This affidavit, which is a boilerplate form that they copy and paste, and Payne forgot to take out Mowry's name from the top of it, but he did fill in all the rest of the information on the copy and paste. But as you can see, this was dated January 6, 2023. And let's read the highlighted part, shall we? It says, the warrant was served on 12/23/2022 by sending to the FBI for service as FBI hosted the pen register and precision location response portion of this warrant. An inventory was prepared for all items received, and the information received was placed into evidence at the Moscow Police Department. This is what they fill out when the information in the warrant comes back. So this was not submitted to Megan Marshall to get the warrant. This was submitted to her after it came back to show that the information was received. The evidence was placed into the Moscow Police Department, inventoried in, and it accompanied Ashley Jennings' request to be sealed. Okay? Because remember, all of these documents had motions to be sealed. This was included with that. Okay, we're going to go back to the state's objection to the motions to suppress. So this was for the pen register trap and trace, and it says that the state's exhibits are attached as follows: affidavit for the search warrant for AT&T with appended exhibits, state's exhibit S1, and AT&T search warrant, state's exhibit S2. And it says the defendant has not demonstrated the search warrant affidavits contain intentionally reckless false statements or omissions. And then 2, the AT&T warrant was not a general warrant. So, the defense is trying to claim that the probable cause affidavit to get the warrant was like Frank's material, that it was recklessly false or had omissions, and then they're also trying to say the AT&T warrant was non-specific, that it was too general. So the state goes on to say, as stated above, the AT&T pen trap and trace search warrant specifically referenced the search warrant affidavit and incorporated Exhibit A with the words proof upon oath, this day showing probable cause. When AT&T search warrant is considered, along with the affidavit for probable cause and the 15-page Exhibit A, the warrants are sufficiently particular and valid. In fact, Corporal Payne set forth why he believed the defendant's cell phone would contain evidence of this crime, specifically why each category of digital evidence listed on the warrant would reveal such information. The AT&T pen trap and trace search warrant and the search warrant affidavit and Exhibit A provide the particularity necessary to satisfy the 3-factor test set forth in Teal. And that's State versus Till, and we're going to take a look at that. But also, when it says Exhibit A, I'm disagreeing with Lana. I don't believe the Exhibit A for that pen trap and trace warrant was the Exhibit A that was the probable cause affidavit for arrest. You can have multiple Exhibit A's because different documents that have exhibits attached will have their own set of exhibits, and you start all over with A, B, C, D again on those documents. So that was Exhibit A for that particular warrant. And I'm not seeing anything that says that they were just using one running probable cause affidavit for every single warrant. Now, if I'm wrong, I'll apologize and say I'm wrong, but I believe Exhibit A for this is completely separate from the Exhibit A that we saw for the arrest warrant. Now, that affidavit is sealed, so we can't see what Payne put in that warrant to get the pen register trap and trace, but Megan Marshall obviously felt there was enough probable cause. Now, I just wanted to remind you, this was the original argument the state was responding to. This is from the original motion to suppress, and it said the search warrant fails to provide specific particularization of what law enforcement could search and seize in Mr. Koberger's AT&T account. It says a warrant, however, is not a magical wand, because you saw earlier, I pointed out that the state said there's no magical words or, magical wand. They're kind of agreeing with that, but they're also saying, hey, Megan Marshall saw proof of probable cause, and she wrote that when she said it was upon oath. So they're saying a warrant, however, is not a magical wand that grants access to anything a cell phone contains. As the Supreme Court found, cell phones can contain an enormous amount of information that is private and may not be viewed by the government. And the defense then goes on to say the warrant for Mr. Koberger's AT&T account lacks appropriate particularization. It lists all of the following that could be found in his account: all identifying information of the account holder, all information about the creation of the account, all information about the account's maintenance, all call records, all text messages, MMS messages or data activity, the device's historical and prospective locations, and any data now in the cloud. It says the warrant and the affidavit are not only all-encompassing, they are duplicative, often repeating things to be searched and seized. The only limitation in the scope is that the property be related to the homicides in this matter. The warrant covers a scope of 6 months' time. And I'm just going to say to that, yeah, it covered a scope of 6 months' time because the 48-hour file had them gone, ooh, we need to look back further into this person's phone records because there was reason to believe there would be information pertaining to the homicides in there. And again, Megan Marshall felt that there was probable cause. Now, going back to the state's response, it says first, probable cause existed to seize all items of a particular type described in the warrant. The specific phone number is listed in the affidavits, and the individual categories of digital information sought are set forth in detail, including why probable cause existed to search those digital files. See AT&T Pen Trap and Trace Search Warrant page 3 through 7, which specifically detail what actions investigators were allowed to take and what information they were allowed to collect. Second, the warrant set out objective standards by which executing officers could differentiate items subject to seizure from those that were not. A, the seizure of items was limited to the crime for which the defendant was arrested, homicide at 1122 King Road in Moscow, Idaho. And B, the warrant temporarily was limited to the time June 23rd, 2022 at 12 to real-time data, i.e. present. Third, the government was not able to describe the items more particularly, considering the information available to it at the time the warrant was issued. Detective Payne was seeking evidence that could be in multiple formats and areas, considering that electronics can be stored anywhere. So then they go on to say it was impossible for Detective Payne to narrow down in advance the AT&T areas that should be searched. As a result, if the court employs a common sense and realistic approach and not the hyper-technical approach the defense is suggesting, the court should find the AT&T search warrant passes the Teal test and sufficiently particular. Then it's got Wheeler versus State as well. And it says, in summary, given the circumstances of this case, the AT&T Pen Trap and Trace search warrant and its respective affidavit and Exhibit A are as particular as can reasonably be expected. Unlike a general exploratory warrant, the AT&T Pen Trap and Trace search warrant allowed for the searcher to reasonably ascertain and identify the things which are authorized to be seized. See Teal. Thus, suppression is not warranted. Okay, so what we've gleaned so far from that was there was a probable cause affidavit attached to the search warrant for Megan Marshall to look over. She approved the warrant. It was sent to AT&T. No, the probable cause affidavit was not attached when it was sent because that's not a requirement. And the prosecution is stating that yes, it was narrowed as good as it could be narrowed, given the information known at the time. And again, Megan Marshall felt that it was specific enough and not exploratory. So we're going to look at the Teal court case next that the prosecution references. Okay, so this is the background on the Teal case, and you can pause and read these because I'm just going to skim through this, but basically police responded to a call from a tavern in Rupert. A bartender informed the officer that she had confronted a man who had his hand inside a poker machine and claiming that the machine had taken his money. The man became agitated and left the tavern with a woman. Several patrons of the bar approached the men and women who was seated in a car in the parking lot and then convinced the woman not to drive away. The man left the area on foot while the woman waited for police. So the officers looked inside the floor of the car and there was the bill collector, which had been removed from the poker machine, but there was no money either in the poker machine or the bill collector. So they decided to go to Teal's apartment. He did not answer, so they applied for a search warrant. So here was the warrant, and they were saying that, showing that the person of Jimmy Teal, evidence of the crime of burglary and or theft, the fruits of a crime, currency, or things otherwise criminally possessed, or other things by means of which a crime has been committed or reasonably appears about to be committed, including currency and other items unlawfully possessed, are located in the following premises, to wit. And then it has his address, describes his apartment, the pink brick fourplex, blah, 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 blah. Says you are therefore commanded at any time of day or night to make immediate search of the above described vehicles. Well, that's important for later. For the property described above and to seize the property on the search warrant affidavit filed herein. The affidavit for the search warrant signed by Officer Arthur specified that he has reason to believe that the person of Jimmy Teal Evidence of the crime of burglary and or theft, the fruits of the crime are things otherwise criminally possessed or other things by means of which a crime has been committed or reasonably appears about to be committed, including currency and other items unlawfully possessed, are located in the following residence, to wit, description of the residence. And it says the language describing Till's apartment as set out in the search warrant was taken verbatim from the affidavit. So it says, before dawn, several officers, including Officer Arthur, executed the search warrant at Till's apartment. After knocking and announcing their presence, they forcefully entered the apartment. Till was quickly located hiding on the floor between his bed and a wall in the bedroom. They handcuffed Till, proceeded to search the bedroom. Underneath the mattress of the bed, Deputy Coyle discovered a syringe and a spoon, which he recognized from his training and experience as drug paraphernalia. Second syringe was located above a door frame in the apartment, along with a second spoon, 2 cigarette butts, and a razor blade. The officers did not locate any currency in the apartment. Subsequent testing of the spoon and syringe found in the bedroom revealed the presence of methamphetamine residue in both pieces of paraphernalia. Till was charged with petty theft, possession of drug paraphernalia, and possession of a controlled substance. He moved to suppress the evidence seized from an apartment, alleging that the search warrant lacked probable cause, was vague and overbroad, and that the search exceeded the scope of the warrant. After receiving testimony and special briefing on the issues, the district court denied the motion. Till entered into an Idaho Criminal Rule 11 plea agreement with the state, whereby he pled guilty to 1 count of possession of a controlled substance, methamphetamine, and the state dismissed the remaining 2 charges. Till reserved his right to appeal from the denial of his motion to suppress. The appeal followed. Till contends that the drug paraphernalia and methamphetamine seized from his apartment should be suppressed as fruits of an illegal search. Although the officers possessed a signed search warrant when they entered his apartment, Till asserts that the warrant did not authorize a search of his residence and lacked sufficient particularity in describing the items to be seized. A valid challenge of this sort normally compels exclusion of all evidence unlawfully seized pursuant to the warrant. See State versus Boussard. However, none of the items seized were listed on the warrant. Instead, they were seized because they were in plain view inside Till's apartment during the search. For the plain view exception to apply, to the warrant requirement to apply, 2 conditions must be met. There must be a lawful intrusion, or the officer must otherwise properly be in a position to view a particular area. It must be immediately apparent that the items viewed are contraband or evidence of a crime. Till does not dispute that the paraphernalia and methamphetamine were immediately recognized as contraband. Rather, he challenges the validity of the warrant to support the officer's intrusion into his apartment in the first place. If the warrant failed to authorize a search of the apartment or lacked sufficient particularity in describing the items to be seized, then the officers were not lawfully in a position to view the contraband and cannot justify its seizure pursuant to the plain view doctrine. So in the appeal, they looked at the place to be searched. Till claims that the officers exceeded the scope of the search warrant because the warrant did not authorize a search of his apartment. The search warrant states, "You are therefore commanded at any time of day or night to make immediate search of the above described vehicles for the property described above and to seize the property on the search warrant affidavit filed therein." Emphasis added. However, nowhere in the warrant or the affidavit is a vehicle described, and at no point was a vehicle searched pursuant to the warrant. Instead, Till's apartment was searched. The state asserts that the use of the word vehicle is merely a typographical error to be ignored because of the obvious intent that the warrant authorized the search of the residence based on the detailed description of the residence found in both the affidavit and the warrant. So they cite a case, Commonwealth versus Burt from Massachusetts. Supreme Court of Massachusetts upheld a search of a residence despite the fact that the warrant authorized a search of a vehicle. The warrant commanded officers to make a search of the interior, the glove compartment, the trunk, and any other possible area of depository of a certain motor vehicle, more particularly described as 8 Village Drive, Walpole, Massachusetts, which is a wood frame cream-colored with brown trim, 2-story raised single-family ranch-style home with 3 access doors on the front, side, and rear, including an attached garage underneath the structure, and owned and occupied by William R. Burt. They said when applying for the search warrant, the officers apparently used a form that was designed for searches of vehicles, even though they established probable cause before a magistrate to search Burt's residence. The court found that the description of the residence was sufficiently particular for Fourth Amendment and state constitution purposes. Similarly, a Texas Court of Appeals upheld the seizure of specific items not commanded in a warrant but listed in the affidavit due to the doctrine of incorporation by reference, which is Eric v. State. The Ninth Circuit also addressed the issue of a technical error in the search warrant and upheld the validity of the search based on a warrant in United States v. Hitchcock. The issuing magistrate signed the warrant on November 16th, but dated it the 17th. The mistake was not noticed until the executing officer made a return of the warrant that same day, at which point the magistrate corrected the error. The court analyzed whether the search exceeded the scope of the warrant based on an objective assessment of the circumstances surrounding the issuance of the warrant, the contents of the search warrant, and the circumstances of the search. However, the subjective state of mind of the officer executing the warrant is not material to the inquiry. Based on the sequence of events on the 16th, the date on the warrant was clearly an inadvertent mistake. Therefore, there was no evidence that the magistrate intended to delay the search by 1 day. So it says here, Officer Arthur applied for a search warrant after being summoned to the tavern during the early morning hours. His affidavit presented sufficient evidence to give rise to belief that evidence from the theft from the poker machine would be located either on Teal himself or inside his apartment. Both the affidavit and the search warrant list the address of Teal's apartment and describes its appearance and location. The only mention of a car refers to Thompson's vehicle. The bill collector was located inside the car where Teal had presumably been sitting, and there was no money inside of it. There is no indication that Teal owned a vehicle, that he had been in a vehicle since abandoning Thompson's car in the parking lot of the tavern, or that there were any vehicles at his apartment when Thompson and Officer Arthur first arrived. Furthermore, Officer Arthur's affidavit requested a warrant to search Teal's apartment and made no references to a car other than Thompson's. Commanding the search of an unknown vehicle contradicts the rest of the warrant. If there had been a blank space instead of the word vehicle, the court's finding of probable cause would be no clearer. The use of the word vehicle instead of residence was obviously a technical error. Consequently, we conclude that the officers did not exceed the scope of the warrant by searching Teal's known apartment instead of an unknown vehicle. Now, B, because this is all part of that three-pronged test, particularity of the items to be seized. Teal also contends that the search warrant was invalid because it was overbroad and did not describe the items to be seized with sufficient particularity. Therefore, he argues that the officers executed a general warrant, which is void, and they were not lawfully in his apartment when they observed the methamphetamine and paraphernalia. The issue of whether a warrant is overbroad or lacks sufficient particularity is a legal question subject to de novo review on appeal. State versus Weimer. The Fourth Amendment requires particularity sufficient to prevent the seizure of one thing under a warrant describing another and to prevent the exercise of discretion by the officer executing the warrant. That was Holman, 109, Idaho. The particularity requirement's objective is that those searches deemed necessary based on a probable cause determination by a magistrate should be as limited as possible. See State versus Caldero. A search warrant must be particular enough so that as to what is to be taken, nothing is left to the discretion of the officer executing the warrant. Marin versus United States. However, this statement is not to be read literally, and it talks about Weimer again. It says, instead, the warrant must enable the searcher to reasonably ascertain and identify the things which are authorized to be seized. United States versus Cook. The warrant authorized officers to search for and seize the person of Jimmy Teal, evidence of the crime of burglary and or theft, the fruits of a crime, currency or things otherwise criminally possessed, or other things by means of which the crime has been committed or reasonably appears about to be committed, including currency and other items unlawfully possessed. The listing of things unlawfully or criminally possessed that may be evidence of a crime is taken from IC 194402, which provides Idaho Criminal Rule 41B. Similarly states, a warrant may be issued under this rule to search for and seize evidence of the commission of a criminal offense or contraband, the fruits of crime, or things otherwise criminally possessed, or weapons or other things by means of which a crime has been committed or reasonably appears about to be committed, or a person named in an arrest warrant issued pursuant to Rule 4. A search warrant may be issued to search for and seize any property or intangible that constitutes evidence of a criminal offense, contraband, the fruits of crime, or things otherwise criminally possessed, weapons or other things by means of which a crime has been committed or reasonably appears about to be committed, and a person named in an arrest warrant. The state concedes that there are only 2 items listed in the search warrant that are described with any particularity, and are in fact the only 2 items the officers were looking for, Till himself and the currency. Till asserts that the word currency was not sufficiently particular, and at a minimum the warrant needed to specify that the officers were searching for United States currency. So, State versus Johnson declares that U.S. currency is a generic class of items, but used by itself is not fatally vague. And then State versus Fitanides is a validating description of U.S. currency because the currency could not have been described with greater specificity. The specificity required in a warrant varies depending on the circumstances of the case and the type of items involved. So basically, he was trying to say because they didn't specify U.S. currency, it should have been thrown out. But case law says that U.S. currency is a good enough description. So I cut out a couple pages more where it goes on talking about vagueness of currency. So we fast forwarded here and it says Officer Arthur may have been able to describe the currency with more particularity. However, the law does not require that level of particularity argued for by Teal. That would not comport with a common sense, realistic interpretation of warrants. Despite Till's assertions to the contrary, currency was a sufficiently particular description in these circumstances. So it says the conclusion. The search warrant authorized a search of Till's residence and provided a sufficiently particular description of an item to be seized. Therefore, the officers were lawfully inside his apartment when they discovered the methamphetamine and paraphernalia in plain view. The district court did not err in denying Till's motion to suppress evidence. The judgment of the conviction is affirmed. So you can see in that they met the 3-prong, which was they had the magistrate sign on it, they had the description of the items to be seized, and the time and place. So keep all of that in mind as we look at what Megan Marshall wrote on the search warrant for the trap and trace. Now keep in mind, we don't have access to the affidavit, the probable cause affidavit. That's sealed, so we don't know exactly what the probable cause was. But per Megan Marshall's search warrant, it says search warrant and order authorizing installation and or use of a pen register, trap and trace device, and non-disclosure order pursuant to IC 186722. It says to any peace officer authorized to enforce or assist in enforcing any law of the state of Idaho. Brett Payne, having given me proof upon oath, this day showing probable cause establishing grounds for issuing a search warrant and probable cause to believe there are records related to the crime of homicide at 1122 King Road, Moscow, Idaho, and are currently under the control of AT&T for historic call detail records for the telephone number 509-592-8458 with cell sites for all voice, SMS, and data connections between June 23, 2022 to the present, to include. So subscriber registration and account identification, device identifying information for the device using the target address, usage and location information, cell site positioning information, so like GPS, longitude, latitude, etc., physical address of cellular antenna towers used by the customer's device, and subscriber identity information for customers who contact or are contacted by the device. And it says located at the following premises. And it says AT&T, 11760 U.S. Highway 1, Suite 300, North Palm Beach, Florida, 33408-3029. You are therefore commanded to search the above described premises for the property described above, to seize it if found, and bring it promptly before the court above named. This warrant will be executed within 14 days of issuance and is authorized for daytime and nighttime service. It says further, there is probable cause to believe that the use of a pen register or trap or trace device will lead to law enforcement acquisition of real-time pen register and or trap and trace information, and that this information would be evidence related to the crime of homicide, which are currently under the control of AT&T. The court finds that Brett Payne, investigating officer, and Ashley Jennings, prosecutor, A deputy prosecutor has certified to the court that the information is likely to be obtained by such installation and use is relevant to the ongoing criminal investigation. And it says, pursuant to IC 186722, subsection 2, the court finds that the identity of the person to whom the phone is leased or in whose name is listed to the telephone line to which the pen register or trap and trace device is to be attached is Brian Koberger. The identity of the person who is subject of the criminal investigation is Brian Koberger, who resides at 1630 Northeast Valley Road, apartment G201, Pullman, Washington. Phone number is 509-592-8458, and the physical location of the phone is currently in Albrightsville, Pennsylvania. So it says the phone service provider is AT&T, and then it says the geographic limits of the trap and trace order are the United States and U.S. territories. It is hereby ordered pursuant to AC 186722 that the above identified investigators and investigative agencies are authorized to install and use a pen register to register, filter, record, and decode electronic or other impulses, including but not limited to dialing, routing, addressing, signs, and signaling information or other impulses that, together with date and time and duration, identify the numbers dialed, electronic mail addressing or routing information, email address, IP address, and other non-content information otherwise transmitted from the target address, and information tending to identify the device using the target address, including any other unique identifiers for the device, including the information referenced above. And it is further ordered pursuant to IC 186722 that the above identified investigators and investigative agencies are authorized to install and use a trap and trace device to trace, identify, register, filter, record, and decode electronic and other impulses, including but not limited to dialing, routing, and addressing signs and signaling information or other impulses that, together with date, time, and duration, identify the numbers dialed, electronic mail addressing or routing information, email address, IP address, and or other we'll go on to the next page. It says content information otherwise transmitted to the target address or other impulses that identify the originating numbers or digital address from which the wire or electronic communication is transmitted, and if known, the customer or username or identity associated with the device, number of addresses sending communications, signals, messages, or other electronic impulses to the above identified target address from any location within the United States. It is further ordered upon probable cause that the above identified service provider, investigators, and investigative agencies are authorized to use a cell site simulator in connection with the target address, and that any cell site simulator device may be used in any geographic area necessary to locate the device using the target address in real time, and that the above listed service provider and any other person served with this order shall, upon request by law enforcement, assist by providing on a 24-hour basis the listed investigative agency with all information tending to reveal or lead to the learning of the locations of the device using the target address, including positioning information such as GPS, longitude, latitude, or multilateralization or precision location, prospective cell site location information, CSLI, or other information tending to reveal the approximate or precise location of the device associated with the target address, including positioning information such as GPS, longitude, latitude, or multilateralization or precise location, prospective cell site location, or other information tending to reveal approximate or precise location of the device associated with the target address. And it is further ordered, for the purposes of this order, that the term cell site simulator, and cell site simulator data include pin register and trap and trace, and data derived from pin register and or trap and trace for the target device, as those terms are defined by IC 186719, and also includes real-time location information collected by a law enforcement operated cell site simulator device and or by a service provider when at law enforcement request the provider deliberately seeks to locate the target device to the extent the terms or technology overlap. It is further ordered that the above listed service provider and any other person served with this order shall furnish agents of the above identified investigative agencies forthwith all information, facilities, and technical assistance necessary to accomplish the installation and operation of the pen register, trap and trace, and cell site simulator, and search of their facilities and records unobtrusively and with minimum interference to the services accorded persons with respect to whom the installation and or use is to take place, and upon request from law enforcement and for the duration of this warrant. AT&T will provide all RTT reports. It is further ordered that this order shall apply to, and the definition of target addresses shall include any other account, target address, network, hardware, or software, identity, or other unique device identifier to which the target address has changed for the 2 months preceding the signing of this order through the end date of the authority granted pursuant to this order, and it is further ordered that the investigators and service providers are authorized to continue using the tools and techniques authorized by this order during any time that the device is being monitored enter private property, and it is further ordered that the investigators and investigative agencies using a cell site simulator shall take all steps necessary to limit collection of any information or methods to the target address, take all steps necessary to permanently delete any information or metadata collected from any party not specified in this order immediately following its collection, and must not transmit, use, or retain such information or metadata for any purpose whatsoever, and must delete any information or metadata collected from the device using the target address within 30 days if there is no longer any probable cause to support the belief that such information or metadata is evidence of a crime. It is further ordered that the listed service provider and any other persons or entity providing assistance be compensated by the above identified investigative agencies for reasonable expenses incurred in complying with this order, and records and information provided pursuant to this order should be provided in the commercially reasonable electronic format and delivered forthwith via electronic mail as specified by the law enforcement officer leaving this order. It is further ordered that this order is effective on December 23rd, 2022 at 4:53 p.m. PST to be completed no later than February 23rd, 2023 of the same time of day. It is further ordered pursuant to IC 18672 4A that this order will be sealed until otherwise ordered by the court, and it is further ordered pursuant to IC 18672 4B that the service provider to whom this order is attached or any other person served with this order is prohibited from giving notice of the existence of this order to any person, including subscriber or customer, to whom the target address relates, except for the service provider may disclose the order to a legal counsel for purpose of receiving legal advice. Given under my hand, dated this 23rd day of December 2022, 4:53 p.m., Megan Marshall. Now, when the FBI submitted it to AT&T, it had their request form as well. And you can see that they checked off only very specific things. Not everything on that check sheet was being considered available to obtain as part of that search warrant. Now, to me, that warrant met the 3 prongs. It was signed by a magistrate, had a specific place, like location, and specific things to be searched for. Like, she laid out in that warrant exactly what was supposed to be searched for. And then she also brought up, not once but twice, about this was related to the homicides. Again, we don't know what was in the probable cause affidavit because that wasn't submitted with this by the defense. That's under seal. But obviously Marshall had probable cause. She signed that. And the cell site simulator. Can we stop now with any of this nonsense that was employed in Idaho? Because Koberger was in Pennsylvania on December 23rd when the warrant was given for a cell site simulator. Now, I still don't understand why they felt the need for a cell site simulator, because they did already know where he was, but one was approved. And that's not approved lightly. But did you notice who had to employ that warrant after Megan Marshall approved it? The FBI. The reason why the FBI served that warrant is because it also included a cell site simulator. As I have been maintaining, Moscow PD does not have a cell site simulator at their disposal. And even if they had one, which they don't, they couldn't have used it in Pennsylvania. Like, FBI has to be involved in that, because then they would have had to contact Pennsylvania. So I'm assuming there's going to be this paper trail here of sealed documents also with Pennsylvania as to whether that cell site simulator was actually employed. Because just because it's in the warrant doesn't mean they actually employed it. They may not have needed to. And also, I'm assuming Pennsylvania has sealed documents about going on the premises and putting the cameras up. Now, that could also be under FBI sealed documents. So that's the whole thing. We may never get to see any of those. But that was the warrant. It does not sound too overbroad to me. But what we're going to discuss next is the defense's argument that the probable cause affidavit should have been included with the search warrant to AT&T, which I still think is crazy, because what's AT&T going to do reading through the search warrant or the probable cause affidavit? So it's not like they're going to have law enforcement officers with there. It's not like when you're searching somebody's apartment and it's law enforcement officers that are going in and doing that. So if they have a copy of the probable cause affidavit, they could also refer to that. But now AT&T, of course, could have their legal counsel look at it. But the thing is, I don't see what extra having the probable cause affidavit would have done for AT&T, because they were given a specific list. It's in Megan Marshall's warrant, and it's also on that form the FBI sent. There's a checklist. And it didn't say everything on Koberger's account. It had specific things. So I feel like trying to challenge it now on this probable cause affidavit needed to be attached is just throwing spaghetti at the wall. But let's take a look at that court case they are referring to. So in this Pilling case, it was appealed to the Ninth Circuit, and the background on it was the Clean Air Act and failure to comply. So the United States charged Breck Pilling with 7 counts of violating the CAA, and each count of the indictment corresponds to a separate work practice standard that the defendant allegedly indicted. So they served warrants as part of this indictment, and one of them was with Google, and they authorized a search of 2 email accounts he had associated with Google. And you guys can pause and read through these because I'm going to go fast with this one. So they executed at least 2 search warrants in this case. In the probable cause affidavit, they put the basis for the search. First, Agent Bird reported that 2 demolition bids had been emailed to breck66@gmail before the demolition of the buildings. And then second, there was reportedly an email sent from the defendant to Breck from the email address Breck@Kodiak America. So the agent concluded that based upon those emails, that those email accounts likely contained emails unknown to the government involving the bids for demolition, asbestos, and other relevant topics. So based upon the affidavit, the magistrate judge authorized a search of the defendant's accounts for evidence, contraband, fruits, and or instrumentalities of violations of the Clean Air Act. The warrant only applied to information from October 1st, 2017 to June 30th, 2018. It also specified the categories of information and records that Google was required to produce and identified the kinds of materials that the government was authorized to seize. Now, there was also an Apple warrant. Government serves the warrant. The warrant authorizes a search of information associated with the defendant's Apple account, mobile phone number, and 2 Apple IDs. In the probable cause affidavit, Agent Byrd reported that the defendant's iCloud account likely contained evidence of obstructive conduct and information related to the defendant's ownership of the demolished buildings. According to information that Agent Byrd obtained during a proffer session with the defendant's former business partner, the defendant made calls, sent text messages, or sent emails to Tibbetts and other relevant parties on or near the date of the first proffer session, as well as on or about June 2nd, 2018. Mr. Tibbetts also told Agent Byrd that he had transferred a recording of his first proffer session to the defendant via airdrop. Based upon the Apple affidavit, the magistrate judge authorized a search of the defendant's Apple account. Attachment A of the warrant described the property to be searched, and Attachment B listed the things to be seized. And it's had all records and information regarding the identification of the account, all records and information about all devices ever associated with the account or used in connection with the account, the contents of all emails from October 1st, 2017 to present, including drafts and deleted emails, the contents of all instant messages from October 1st, 2017 to present, including drafts and deleted messages, the content of all files stored on the iCloud, including those related to email, photos, document drives, passwords, address books, contact lists, notes, reminders, calendars, images, videos, voicemails, device settings, and bookmarks, all activity, connection, and transactional records, including those related to FaceTime, messaging, email, iCloud, iTunes, the App Store, and the Game Center, all records and information related to account access, device locations, and services used, all records of communication with Apple regarding the account, and all files, keys, and information necessary to decrypt the disclosed data. So I can kind of see how this is already overbroad because the App Store and the Game Center, I'm not really, and iTunes, not really seeing how any of those would relate with violating EPA policy. Now, Section 2 of Attachment B listed the information and records that the government was authorized to seize, including all information described in Section 1 that constitutes fruits, contraband, evidence, and instrumentalities of violations of the Clean Air Act, conspiracy to defraud the United States, false statements, obstruction of agency proceedings, witness tampering and destruction, alteration of evidence, and then information pertaining to the Clean Air Act violations, conspiracy, false statements, obstruction, witness tampering and destruction, alteration of evidence. Evidence indicating how and when the email account was accessed or used to determine the geographic and chronological context of the account access, use, and events relating to the crime under investigation and to the email account owner. Evidence indicating the email account owner's state of mind as it relates to the crime under investigation. The identity of the person who created or used the user ID, including records that help reveal the whereabouts of such persons, and the identity of the person who communicated with the user ID about matters relating to the affirmation violations, including records that, oops, I cut that off, but it was about revealing the whereabouts of that person. On November of 2022, Apple provided and the government downloaded approximately 118 gigabytes of data pursuant to the search warrant. In May of 2023, after filtering the data to exclude presumptively privileged results, the prosecution team began to search and review the files. On January 30th, 2024, the government realized that it had inadvertently failed to purge the data of files that did not fall within the categories authorized for seizure under Section 2 of Attachment B. The government did so and was left with 156 responsive documents, 9 of which it intends to offer at trial. Motion to suppress. The defendant filed this motion on January 19th, 2024, seeking to suppress all evidence seized pursuant to the Google warrant and the Apple warrant. He argues that both warrants are overbroad and lack particularity in violation of the Fourth Amendment to the United States Constitution. I'll let you pause and read this part because it's not really that important into the decision making. And then legal standards, just a good explanation again of the Fourth Amendment and probable cause being the bedrock of every search warrant. And it talks about specificity having 2 aspects, particularity and breadth. Particularity is the requirement that the warrant must clearly state what is sought, and breadth, having problems tonight, deals with the requirement that the scope of the warrant be limited to by the probable cause on which the warrant is based. And this cites more case law about specificity. This principle keeps the government from seizing the haystack to look for the needle. In doing so, it protects against the specific evil of a general warrant. A search warrant is not overbroad if its scope is supported by probable cause. And that was U.S. versus SDI. The search and seizure of large quantities of material is justified if the material is within the scope of the probable cause underlying the warrant. In determining whether a warrant is overbroad, a court must consider whether probable cause existed to seize all items of a category described in the warrant, and whether the warrant set forth objective standards by which executing officers could differentiate items subject to seizure from those which were not, and 3, whether the government could have described the items more particularly in light of the information available. Unique challenges arise when executing search warrants on electronically stored information. That is because there's no way to be sure exactly what an electronic file contains without somehow examining its contents. It says, given those challenges, the federal rules provide for a 2-step process when officers may seize or copy the entire storage medium and review it later to determine what electronically stored information falls within the scope of the warrant. At the same time, courts have also recognized that the nature of digital storage creates enormous risks of authorizing unbridled exploratory searches of electronically stored data. Thus, while the Ninth Circuit has acknowledged that the reality of overseizing is an inherent part of the electronic search process, it has also emphasized the need for greater vigilance on the part of judicial officers in balancing the needs of law enforcement and the privacy rights of the people. Law enforcement and judicial officers must be especially cognizant of privacy risks when drafting and executing search warrants for electronic evidence. Now they have the discussion. So the defendant's motion will be denied to the extent that it challenges the Google warrant. That warrant is not overbroad and sufficiently describes the place to be searched and the things to be seized. However, the defendant's motion will be granted as to the Apple warrant, which lacks the degree of particularity required by the Fourth Amendment. So the Google warrant was not overbroad. The defendant first argues that the Google warrant was overbroad. Based on the existence of a few emails, he explained the government seized information from every corner of his electronic life, including volumes of other types of information that might be tangentially attached to a digital account. The government responds by noting that the Google warrant imposed subject matter, categorical, and temporal limitations that were reasonable under the circumstances. Moreover, the government explains the unique challenges of searching electronic records did not allow for the kind of specificity that the defendant suggests. In United States v. Palaio, the Ninth Circuit rejected a broadness challenge under similar circumstances. There, as here, a warrant authorized a search of the defendant's iCloud account. Although the warrant required Apple to produce the entirety of the iCloud account under Step 1, the search and seizure of evidence was limited to the outlined crimes, and the warrant specified 21 types of evidence that the government could seize. Excuse me. Those limitations were adequate to prevent the warrant from becoming a general warrant that would allow the executing officer to rummage through his iCloud account without discretion. The Google warrant is similar to the search warrant upheld in Palaio. At the outset, it lists broad categories of data to be disclosed by Google. It then narrows it into a list in several respects. First, it imposes a temporal limitation only authorizing a search of information from October 1st, 2017 to June 30th, 2018. That date range spans from the time buildings were allegedly purchased until shortly after the defendant's alleged email communications regarding his engagement with the EPA. Based upon Agent Bird's representations in the Google affidavit, the court concludes this 9-month window was reasonably rooted in the magistrate's probable cause finding. Next, the warrant limits the government to seizing information and records that constitute fruits of contraband evidence and instrumentalities of violations of the Clean Air Act. And finally, the warrant lists 8 specific categories of evidence authorized to be seized. Kind of interesting because I feel like Megan Marshall was pretty clear with her scope on that AT&T warrant, kind of like this Google one. But applying the 3 factors outlined in the Ninth Circuit in Leishi, the court concludes that the Google warrant was not overbroad. First, the scope of the search warrant was supported by probable cause. Agent Bird identified emails passing to and from the Google accounts in which the defendant collected bids for the destruction of the buildings and communicated with his business partner about his dealings with the EPA. 2 of those emails contain file attachments based on the defendant's alleged use of the email accounts to communicate about the building demolition and asbestos testing. The magistrate judge properly found probable cause to search the accounts for other emails related to the buildings and presence of asbestos. Yada, yada, yada. You can read the rest. Second, as further explained below, the warrant established objective standards by which the executing officers could determine which items were subject to seizure. Attachment B tied each category of material to the suspected crime and delineated the kind of evidence to be seized. Finally, the government could not have been more specific in light of the information available. The defendant argues this search should have been confined to email communications between parties identified by the government in its supporting affidavit, but such a limitation would have created a substantial risk of excluding relevant records, for example, demolition bids provided by other contractors and communications between the defendant and other business associates about the presence of asbestos at the demolition site. The government limited the scope of the warrant to a reasonable degree in light of the information upon which the warrant was based. In sum, the Google warrant was not overbroad. Its scope was supported by probable cause described in sufficiently clear terms and not reasonably susceptible to a greater degree of specificity. The Google warrant was sufficiently particular. The Google warrant also sufficiently particular because it reasonably identified the place to be searched and the things to be seized. To begin, the defendant argues that the Google warrant did not adequately describe the place to be searched. The relevant test is whether the warrant describes the place to be searched with sufficient particularity to enable law enforcement officers to locate and identify the premises with reasonable effort, and whether any reasonable probability exists that the officers might mistakenly search another premise. The Google warrant clearly identified the place to be searched. It said proper to be searched, and it had those email addresses associated with it, and then the headquarters for Google. And it says that description enabled law enforcement officers to identify the place to be searched with reasonable effort and created little or no risk that the wrong place would be mistakenly searched. Next, the defendant argues that the Google warrant lacked particularity because it did not specify how items to be seized related to the designated crimes. As discussed above, the warrant did describe the items to be seized with reasonable specificity. First, it only authorized the seizure of items that constituted fruits, contraband, evidence, and instrumentalities of violations of the Clean Air Act and or 50 CFR 6145. Second, it further limited what could be seized by listing 8 specific categories of information related to the alleged crime. For example, the warrant authorized the seizure of any emails or email attachments related to the purchase or ownership of the property buildings located at 1222 or 1226 Overland Avenue in Burley, Idaho. Blah, 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 blah. In sum, the Google warrant was not overbroad and it contained sufficient particularity to satisfy the Fourth Amendment. The defendant's request to suppress evidence obtained pursuant to the Google warrant would therefore be denied. Now we get to the Apple warrant. The defendant argues next that the Apple warrant was overbroad, lacked particularity, and was executed improperly. The court agrees that the warrant did not adequately describe things authorized to be seized. Moreover, the government's failure to purge the data within a reasonable time frame violated the defendant's Fourth Amendment rights. Evidence obtained pursuant to the warrant will therefore be suppressed. The Apple warrant failed to particularly describe things authorized to be seized. The warrant authorized a search of the defendant's entire iCloud account for fruits of contraband, evidence, and instrumentalities of violations of 5 statutes. While the supporting affidavit detailed the facts and circumstances underlying the magistrate's probable cause finding, it is unclear whether its affidavit accompanied or was incorporated into the warrant itself. Consequently, the warrant provided almost no guidance as to what things the government was authorized to seize. In doing so, it violated the Fourth Amendment. At its core, the particularity requirement of the Fourth Amendment means that the warrant must be specific enough to enable the person conducting the search reasonably to identify the things authorized to be seized. Naturally, the degree of specificity required varies depending on the circumstances of the case and the type of items involved. Sometimes it is simply impossible to use more than generic descriptions of the items likely to be found during a search. Still, the Ninth Circuit has marked a cautious path when dealing with warrants that use generic descriptions and rely merely on references to the laws suspected of having been violated. The Ninth Circuit considered a challenge to the particularity of a search warrant in U.S. v. Spilotro. There, a search warrant was issued against individuals suspected of engaging in an unlawful loan sharking and gambling activities. The warrant authorized law enforcement to search the defendant's stores and seize address books, notebooks, notes, documents, records, assets, photographs, and other items and paraphernalia evidencing violations of the multiple criminal statutes listed. The warrant failed, however, to indicate the precise identity, type, or contents of the records sought. The court held that the warrant lacked sufficient particularity because it authorized the wholesale seizure of entire categories of items and provided no guidelines to distinguish items used lawfully from those the government had probable cause to seize. The only limitation was the warrant's reference to the laws that the defendants were suspected of violating. But that reference alone did not provide sufficient guidance to satisfy the Fourth Amendment standard of particularity. The government urged the court to read the warrant in light of the supporting affidavit, which exhibited the required degree of specificity. The court refused. We are unable, it explained, to rely on the affidavit to cure the generality of the warrants. And that's what Massoth quoted, since it was not attached to and incorporated by reference in the warrants as required by this court's decision. In another case, the Ninth Circuit distinguished Spilotro and rejected a defendant's particularity challenge. There, a warrant authorized a search of the defendant, his vehicle, and his residence for evidence of extortion. The warrant specified the kinds of things to be seized, including records, documents, and materials, which reflect communications with particular individuals, and any and all evidence of travel, including hotel bills, receipts, gasoline receipts, or any other documentation related to travel from January 8, 2004 to the present. The court distinguished the warrant from the one challenged in Spilotro and found that it contained adequate specificity and sufficiently restricted the discretion of agents executing the warrant. Further, unlike in Spilotro, the extensive 24-page supporting affidavit describing the extortion scheme in detail was attached to the warrant. The warrant was sufficiently particular because it provided a specific list of possible documents that fell within this category and temporarily restricted the breadth of the search. Moreover, the extensive statement of probable cause in the affidavit detailed the alleged crime and Johnny's unlawful scheme. The Apple warrant resembles the warrant invalidated in Spilotro in two important respects. First, the Apple warrant itself did not provide any real guidance for the executing officer to determine what kinds of information and records may be seized. Instead, it broadly authorized a search of the defendant's entire iCloud account for information or records that constitute fruits, contraband, evidence, and instrumentalities of violations of 5 statutes. Unlike the warrant upheld in Johnny, the Apple warrant did not state the identity and nature of the items to be seized, nor did it describe in any detail the items one commonly expects to find on the premises used for the criminal activities in question. There is ample case law in this circuit demonstrating that a search warrant's bare reference to evidence of a violation of a certain statute is generally insufficient to satisfy the particularity requirement. The catch-all phrase authorizing seizure of fruits and instrumentalities of a violation. And it did not adequately describe the items to be seized. Caldwell, it says, finding insufficiently particular a warrant authorizing a search for fruits, instrumentalities, and violations. Second, the supporting affidavit apparently did not accompany the Apple warrant at the time of the execution. Consequently, as in Spilotro, the significant details set out by Agent Byrd cannot cure the generality of the warrant. We consider the affidavit to be part of the warrant and therefore potentially curative of any defects only if the warrant expressly incorporated the affidavit by reference and the affidavit either is attached physically to the warrant or at least accompanies the warrant while agents execute the search. Viewed on its own, without context provided in the affidavit, the Apple warrant simply cannot satisfy the Fourth Amendment's particularity requirement. The fact that the application adequately described the things to be seized does not save the warrant from its facial invalidity. The Fourth Amendment, by its terms, requires particularity in the warrant, not in the supporting documents. The government claims it could not have provided more detailed descriptions of the items to be seized, given the unique challenges of searching electronically stored data. The court disagrees. The warrant could have been more specific in several ways. First and foremost, the government could have incorporated the supporting affidavit and ensured that it accompanied the warrant at the time of execution. Doing so would have substantially increased the degree of guidance for the warrant's execution. The warrant also could have described the kinds of things authorized to be seized, such as emails, text messages related to the buildings or the EPA. The government could have narrowed most of the descriptions in the warrants either by describing in greater detail the items one commonly expects to find on the premises used for the criminal activities in question. Instead, the warrant simply punted to the executing officer, allowing that person to scour the defendant's entire iCloud account for information obtaining to the suspected criminal activity. The warrant's reference to 5 criminal statutes did not add a sufficient dose of particularity to save the warrant. It's true that the references to suspected crimes are relevant too, and sometimes sufficient to establish particularity. Reference to a specific illegal activity can, in inappropriate cases, provide substantive guidance for the officer's exercise of discretion in executing the warrant. But the Apple warrant merely listed 5 broad statutes. Beyond including parenthetical labels, the warrant provided no further guidance. Moreover, those criminal statutes were not specific enough to impose adequate inherent guidelines, as is true when the suspected crime is highly specific. It says United States versus LeBron, noting that a reference to a specific illegal activity like narcotic sales would provide a particularized description and inherent guidelines. Wouldn't quadruple homicide pretty much describe that? Let's see. It says rejecting a particularity challenge because limitation of the search to evidence of child pornography was sufficiently specific. Instead, the listed statutes were of exceptional scope and provided little guidance of their own. The outcome may have been different if Agent Byrd's affidavit had been incorporated into and accompanied the Apple warrant. That is, the warrant's instruction to search for evidence of violations of the 5 statutes would probably be sufficiently particular if combined with the information set forth in the affidavit. Without that information, however, the executing officer was left with no way of determining what constituted evidence of, say, conspiracy to defraud the United States or obstruction from agency proceedings. Okay, I'm going to say that what constitutes evidence of planning a homicide would be pretty self-explanatory. I don't know. In sum, the Apple warrant authorized a search of vast swaths of data, but failed to particularly identify the things to be seized. That gave executing officer near total discretion to rummage through the defendant's iCloud account and seize anything that appeared to be fruits, contraband, evidence, and instrumentalities of the suspected crimes. The Fourth Amendment demands more. The good faith exception does not apply. In United States v. Leon, the United States Supreme Court upheld that evidence obtained pursuant to a facially valid search warrant, later found to be invalid, is admissible if the executing officers acted in good faith and in objectively reasonable reliance on the warrant. However, the court noted that there may be instances where a warrant is so facially deficient, i.e., in failing to particularize the place to be searched or the things that be seized, that the executing officers cannot reasonably presume it to be valid. Reliance is per se unreasonable, where the warrant is facially deficient in detail as to the place to be searched or things to be found that the officers could not reasonably presume it to be valid. The Ninth Circuit has applied the good faith exception where the government showed that an unattached, unincorporated probable cause affidavit actually limited the search. In United States versus Look, the court affirmed a district court's application of the good faith exception to deny a suppression motion. The search warrant there was constitutionally defective for lack of particularity because the affidavit was not expressly incorporated into the warrant by reference. As the court explained, however, that did not preclude the use of the executing officer's reliance upon the affidavit as evidence of their reasonable reliance on the validity of the warrant or their good faith. Indeed, the district court had found that the agents specifically relied on the affidavit and acted in good faith by limiting their search to the items described in the affidavit. Now that's interesting. Because if it's the officers that are looking through everything on those accounts after like AT&T or Google give them the information, then who's to say the officer doesn't have a copy of the probable cause affidavit sitting there with them, especially because we already know the FBI agents were there at the Moscow Police Department with Mowry and Payne. So that got me thinking on that one now. To invoke the good faith exception in this context, the government must show that the individuals who executed the warrant actually relied on the affidavit. Refusing to apply good faith exception absent evidence that the executing officers actually relied on the information in the affidavit to limit the warrant's overbreadth. Here, the government merely referenced the good faith exception in a footnote, although the court will not deem the argument waived. The government certainly has not carried its burden showing that the exception applies in this case. The doctrine of severance does not apply. The Ninth Circuit has embraced the doctrine of severance, which allows a court to strike from a warrant those portions that are invalid and preserve those portions that satisfy the Fourth Amendment. Only those articles seized pursuant to the invalid portions need be suppressed. In an exhibit attached to the surreply, the government identified the 9 items of evidence obtained pursuant to the Apple warrant that it intends to offer at trial. To the extent the court invalidates the Apple warrant, the government asks that the invalid portions of the warrant be severed from the valid portions and that the 9 text messages be admitted under the doctrine. But the doctrine of severance cannot be applied to the Apple warrant under the circumstances. Severance is only appropriate as to identifiable portions of a warrant where it is feasible to exercise the problematic portion, where it is feasible to excise the problematic portions from the valid ones. Courts must also consider the relative size of the valid and invalid portions of the warrant. Severance is not appropriate where only a relatively insignificant portion of the warrant is valid. Here, the 9 text messages sought to be introduced appear to have been obtained under the language of the warrant authorizing the seizure of fruits, contraband evidence, and instrumentalities of violations of the suspected crime. That is the same language the court finds lacking in particularity. Moreover, even if the text message portion of the warrant could be severed, that portion would be relatively insignificant compared with the vast scope of the warrant. In sum, severance does not apply here, and the evidence obtained pursuant to the Apple warrant must be suppressed. So, basically, if they're saying you only find a few things in that whole big mess of evidence, or of information, not evidence per se, then it can't be severed. Which, yeah, so basically they're like it mentioned earlier about a needle in a haystack. It says suppression is also justified because the government did not filter unresponsive data before reviewing the defendant's entire iCloud account. There is another independent basis for suppressing the evidence obtained pursuant to the Apple warrant. Namely, members of the prosecution team performed a months-long review of the defendant's entire iCloud account before excluding the information and records not authorized to be seized. The government insists that its failure to conduct the second step of the process outlined in the warrant was inadvertent. That may be, but under the circumstances, the court need not and does not make a factual finding to that effect. Even if the government did not intentionally violate the terms of the warrant, its detailed review of the defendant's entire iCloud account over the course of nearly 9 months plainly violated the defendant's Fourth Amendment rights. Now, I'm not saying where Massoff made a claim that any information wasn't deleted like it was supposed to, so I don't think that part applies at all. Excuse me. To be sure, Fourth Amendment violations do not always require application of the exclusionary rule. The judicially created exclusionary rule is a deterrent sanction that bars the prosecution from introducing evidence obtained by way of a Fourth Amendment violation. It is not, however, a personal constitutional right, nor is it designed to redress the injury occasioned by an unconstitutional search. In sum, even if the warrant had not lacked particularity, the court would likely suppress government's evidence on this independent ground. It is ordered that the defendant, Breck Pilling's motion to suppress, is granted in part and denied in part, as follows. The motion is granted as to the evidence obtained pursuant to the Apple warrant, and it's denied as to evidence obtained in pursuant to the Google warrant. Wow. Okay. A lot to really unpack there. Whoops, this stupid little piece of hair. I hope I didn't bore you too much on going through that, but I think it's important to go through some of this case law that they reference. Um, in my opinion, I don't see this applying too much to this pen register trap and trace and the 6-month AT&T file. I could see it more being an issue with the Google warrant and the Apple ID. But the pen register trap and trace to me was very specific with what things could be accessed. The premises was listed. Also, if you're talking about the officers that are going to be going through the files, which I'm assuming was going to be Agent Balance and others, they were there in the Moscow PD office with Mowry and all them. So they could have looked at a copy of that probable cause affidavit anytime they needed to if they weren't sure on specificity of something. AT&T wouldn't need that. So to serve it to AT&T as a third party with that probable cause affidavit attached is just crazy. That never happens. You don't ever serve that to the third party. You just give them the warrant, not the probable cause affidavit. So, and I think to me, homicide is pretty specific with what you're looking for, especially when we're also talking about third party doctrine, when again, things like phone records, etc., traditionally didn't need a warrant until just recently, and many things, including like Google and Apple, still don't really need a warrant. And homicide's pretty specific. Like if you're looking for planning of a homicide or signs in the phone of surveillance or anything like that, I don't think that's vague. I think that's pretty specific. So it's going to be interesting to see what Judge Hippler decides. But I can see this applying again more to like the Apple and the Google, like because I think was it his Apple ID they went back to 2016, because this AT&T warrant's very specific. It's a 6-month look back. They're looking for that period when he moved to Pullman. They are very specific in what they're looking for. But unfortunately, we also can't see that probable cause affidavit to know exactly what was listed in there, but it was certainly enough for Megan Marshall to approve all that, plus a cell site simulator. And I don't think they do those very lightly. Now, let's listen to a little bit of old Pavarotti talk about this as we move on.
I mean, they may have checkmated the prosecution in this process. Now, the reason I say this is an example of some brilliant lawyering is because once I realized what the defense was doing right here, I went back to the original motions to suppress and I looked at all of the arguments as it relates to these 5 motions. Nowhere in there do they cite the fact that a warrant without an affidavit submitted along with it is an invalid warrant and therefore should be suppressed. That argument wasn't in any of their motions. They literally, when you talk about chess, they filed those motions, waited for the state to object, and saved this particular argument for their replies. And I mean, it is a beast of an argument.
Well, I personally don't think it's a beast of an argument, but we shall see. But they kind of precluded that they were heading this direction in the original motion to suppress, because here they talk about the lack of specificity and particularization. So you could tell that they were already trying to go after it being too broad of a search warrant. So then when the state replied how they did, the defense countered back with, well, you should have attached the search warrant or the probable cause affidavit to the search warrant because you weren't particular enough. So yes, it is chess, but I don't believe it's a checkmate at all. But we shall see.
The reason the motion was granted in favor of the Apple warrant is because the affidavit did not accompany the Apple warrant that was submitted to Apple by law enforcement. The Google did. Since the Google did, they denied it. But since the Apple didn't, they granted it. And Ann Taylor has a identical argument as this case, down to the T, and all of those 5 that we're talking about hinge on that right there. And they wait.
Wow. We just went through that whole case law, and that's not why one got granted and one got denied. They both did not have the probable cause affidavit attached. So it's not that one had it attached and one didn't. It was just, it came down to particularization and specificity. Word of the day that I do not like pronouncing. And I don't think these are identical. I just said that the pen register trap and trace definitely isn't. I think maybe Google and Apple might be close, but again, there's a lot of differences. There's not a lot of similarities, but that's just my opinion. The rest of you may have different opinions, and that's why it's great to discuss this. So let's move on to the next item that I want to clear up.
Warrants that you shouldn't be getting because you're not even signing your own affidavit to it. You're taking someone else's sworn statement and assigning your name to it. You're not allowed to do that. That's a fabrication of a document. That's a fraudulent document that we're looking at that was submitted not only to the court, but to the FBI. So this got past Meghan Marshall, by the way.
Actually, it's not a fraudulent document. It's a boilerplate document that then they copy and paste, and they fill in their own name, and they put in the date, and they put in the specifics. He just forgot to erase Mowry's name and put his in. That's not saying that he used Mowry's probable cause affidavit and signed on to that. That's just a particular boilerplate form. I pointed out earlier that one's used when the items come back and then they take it to the judge to say, hey, we received everything back, it's been put in evidence, and now we need this sealed. Okay? And the defense also uses boilerplate forms, and they also copy and paste. I pointed out last week several times where the defense was copy and pasting wrong dates into the paperwork. No one's perfect. Yes, you want 100% accuracy, but unfortunately, things happen. Typos happen. Things like this happen on boilerplate documents. But I'm going to show you some of the ones of the same form that have been submitted. So you can see here I highlighted where the name goes in, and then you can see kind of those little things that got copied over that are still showing up with the parentheses. And then again, you change the name there, and then at the bottom it says affidavit. Just a basic boilerplate form. I accidentally highlighted the Bates number. Didn't mean to do that because that's not part of the form. And you can look at this one again where the state of Idaho, county of Latah was copied over something else. And then, if you'll notice, their boilerplate form says affidavit instead of affiant. So whenever any of them are submitting this form, it says affidavit there. And if you look at this one, Mowry forgot to put his name up there. So it says officer. That's where you're supposed to remove and put your name in. But this doesn't mean that they're swearing somebody else's affidavit or that they're violating any law or violating anyone's constitutional rights. Here's another one where he put officer. And again, still the same old copy and paste where state of Idaho is. And then, affidavit instead of affiant again. That's the thing with boilerplate. You gotta watch when you're copying and pasting. And then here's one other one. Payne did this one. And I'll just refresh on the little case law that we read earlier because I thought this was appropriate. When applying for the search warrant, the officers used a form that was designed for searches of vehicle, even though they established the probable cause was for the resident. Basically, because it was a typographical error, it was okay. Same thing with the date, because I know, Miss Potts, you had brought up about the warrant being signed on the 23rd and then being served on the 24th. It's likely they could not issue it to AT&T that afternoon by the time Meghan Marshall signed it. So they sent it in the morning. But that's still an inadvertent error about the date. So it's, again, not anything to get your hackles up about.
The pen register trap and trace started 12/23/2022, and it went through February 23rd, 2023. Okay? What the fuck? And the historical records went from, look at this, June 23rd, 2022 to December 23rd, 2022. Okay? That's interesting. So your pen trap and trace starts on the 23rd and goes through February. You arrested him December 30th, correct? Right? So why do you need your pen trap and trace to go through February 23rd if he's been in jail, basically in custody, since December 30th? Well, like I don't know shit. So that's why I say I don't know shit. I just read the documents and I ask questions, right? That's all we do here. But it's very interesting, in my opinion, that you're applying for a pen register trap and trace. You want it to start on December 23rd, and you want it to end February 23rd. That's interesting. If he's been in custody since December 30th, why would you need your pen trap and trace to produce records for you all the way into February if he's in custody? That's why it was extended through February, but to be completed no later than February 23rd. If you already know he's in Pennsylvania and the FBI is already watching him, why are you even applying for the pen trap and trace? You already have eyes on him. You're watching him through the scopes of your rifles in the home, right? This is the thing that's confusing to me. How and why would you need your pen trap and trace to extend beyond after the person's in custody?
For 12/23 of 22 to end on 2/23 of 23? Every 15 minutes. So they're pinging his device every 15 minutes for 2 months, even after they've arrested him? Is that what that means? Because I don't know. That's kind of crazy.
Why is this so hard to understand that these search warrant dates went after the arrest date? They applied for the warrant on December 23rd. Koberger was not arrested till December 30th, okay? But they didn't know when he would be arrested when they applied for the warrant. So what do? You give yourself a buffer because you're not sure when the process is going to get completed. So let's say you only took out the warrant for a week thinking that, oh, they'll arrest him quick, and then he doesn't get arrested right away. Now you have to re-extend the warrant. It's better to take it out going until February so that you have it in place, okay? They didn't put it in place after he was arrested, okay? It's extending beyond his arrest date because the warrant was done before he was arrested. This isn't rocket science. And no, they weren't still doing that after they arrested him because then they had his phone. So they didn't need that AT&T warrant anymore. But the whole thing was, it came out, it was approved before he was arrested, and you have to give yourself a good buffer time. I really don't understand why people are getting so hung up on that.
And then we can see here that if you look, now Payne swears that the warrant went in on the 23rd, December 23rd. But if you look right here, it says right here, 12/24, 2022. Okay. Now, the date and time it was signed, look at that. 12/23/2022 at 5:53 p.m. I think that's what Elisa Masseth is getting to here. I think that's what she's alluding to in this filing, is like when you actually go and look at the dates and the times, something's wrong here, because Payne is swearing that this was served by the FBI on December 23rd, and the FBI is producing a receipt saying, no, bitch, we didn't serve it till the 24th. We don't know what he's talking about. And our trap and trace extends to this date.
Yeah, except that's not what the FBI is saying. If you see this document signed by Nick Balance, he said it was served on December 23rd. So he's not disputing what Payne said at all. And again, I think it's probably a workday thing, because by the time they got it was almost 6 p.m. They're at Salt Lake City Mountain Time. So they probably served it the next morning. And it's not a big issue.
Non-disclosure order included. Oh, so there wasn't a non-disclosure order or any sort of gag order whatsoever on 12/23, but I'm pretty positive just off the top of my head that by 2/24 of 23 we had that gag order already. I don't remember exactly whenever the madness started, but this was written up on 2/24 of 23.
Yes, you are correct. The gag order didn't go into effect till after. It actually went into effect January 3rd. But even though Nick Balance wrote this report up talking about when the affidavit was served, even though he wrote it in February, they sent NDO orders over to AT&T with the initial warrant back in December. That was completely separate from the gag order that was implemented in January. The part on the bottom talking about the non-disclosure order was present on there when that was submitted to AT&T in December of 2022. It was not added in February of 2023.
Then, as you can see here, we get to the carrier request form. It tells you it's the FBI out of Salt Lake City, Utah. Okay, which is interesting. There's probably not a lot of you that know why I think that's interesting, but I'll tell you why. And it's because our lead detective here, if you were present for the live where I read Payne's wolf hunting article there, any of you, there may be a few of you that were able to make it to the live I did probably about a month and a half ago, where I read out loud an article covering Brett Payne and his hunting buddy killing that wolf, right? Well, his buddy just so happens to be from Salt Lake City, Utah. So I just thought it was interesting that the FBI out of Salt Lake City, Utah was brought in on this case, a field agent out of Salt Lake City, Utah. Interesting.
Actually, no, his buddy's not from Salt Lake. He grew up in St. Mary's with him, but he went to school down in Logan, Utah, and he does not live in Utah. He moved out of Utah after he graduated from college. Has nothing to do with the Salt Lake City field office. Now, for those of you who are wondering why it was the Salt Lake City field office assigned, that's because Salt Lake is in charge of Utah, Idaho, and Montana. So the agents come out of their field office. Now, yes, there are all kinds of little sub-offices all over. There's like one in Boise, there's one in Lewiston, there's one in Coeur d'Alene, but they're all under Salt Lake City. And you can see the 3 states there that are under the Salt Lake office. So this isn't some big conspiracy with Brett Payne's hunting buddy. Can we just please knock off all of these stupid things that you try to drag into this case that have nothing to do with anything? So I know that was a long one, uncharacteristically long for me, but I felt that it was important to go through all that. I felt that it was important to write some of the misinformation that was out there. And thank you for bearing with me. If you fast forwarded through it, that's fine. If you watch it, that's fine. If you stayed with me, go buy yourself a drink, okay? Let's all go do a shot together sometime. We really need to. But As always, if there's something you want me to cover, let me know. And thank you so much for the words of support that I've been getting. It means so much to me, especially people that are close to the families or family members. So I really appreciate that. And I do this in honor, in memory of the 4 beautiful souls that are no longer with us. So everybody have a good Monday.